We're going to start on our second panel of the day, which is titled Arbitration versus Litigation, Can the Hague Foreign Judgments Convention Change the Game? We have three great speakers again here with us, and it is moderated by Zaid Wahadi, GIS's Vice President. We're excited to have our three speakers, Professor Stewart, Alex Wilbraham, and Joe Profaizer. I'm sorry, I didn't confirm.
Joe Profaizer.
Profaizer. I'm so sorry, y'all. Okay, so I'm going to start off by introducing David P. Stewart. He's a professor from practice teaching international and transactional law at Georgetown Law. He also co-directs the Global Law Scholars, which I'm proud to be a member of, and the Center for Transnational Business and Law. Professor Stewart has had a long career in the Office of Legal Advisor, U.S. Department of State, where he served as an assistant legal assistant for private international law, diplomatic law and litigation, African studies, African affairs, human rights and refugees, law enforcement and intelligence, and international claims and investment disputes, among other positions. He's the past president and current chair of the board of directors of the American branch of the International Law Association and a member of the International Law Institute. Also for the Foreign Relations Law of the United States, published in 2018. He serves on the board of editors of the American Journal of International Law and the Secretary of State's Advisory Committee on Private International Law. The OAS General Assembly have elected him twice to serve on the International American Judicial Committee. If you could give you a round of applause for Professor Stewart. Great. We'll just do that after each one. The next on the panel is Alex Wilbraham, who currently works at Freshfields as counsel and heads the firm's Brazil disputes practice. He previously worked in the firm's Paris office. Alex has extensive experience in arbitrations relating to Latin America and having advice on disputes concerning energy, telecommunications, insurance, banking, and international trade. He has also been appointed by the ICC to act as a sole arbitrator and recently acted as counsel in an ICC arbitration concerning one of the largest corporate disputes in Brazilian history. Alex speaks 7 languages, speaks English, Spanish, Portuguese, French, Russian, German, and Italian. Sorry. Okay. Joe Profaizer. We're going to do that again.
Profaizer.
Oh, I could do that. Profaizer. I'm putting an acronym to it that I don't need. Profaizer is a partner in the litigation practice and the global head of international arbitration practice at Paul Hastings. Joe, who is based in Washington, D.C., is also an adjunct professor of law here at Georgetown, where he teaches a course in international arbitration and international litigation. Mr. Profaizer is dual qualified and has practiced in both the United States and England. He has served as counsel in the threatened or legal action or arbitration in over 50 countries and has successfully represented clients in the U.S. and federal courts at both the trial and appellate levels, as well as in over 70 arbitrations under all of the major international arbitration rules, which is quite exciting, y'all. You just do a final round of applause and then I do want to add the following disclaimer. All panelists are participating in this panel on their personal capacities only. Their views, comments, and opinions expressed by them are their own and not that of their employers. A recording of the session will be made available to Georgetown Law affiliates and should not be shared outside of the Georgetown Law community. Thank you guys so much, and I really hope you enjoy this next panel. And then make sure that you're staying also after for our networking next session. Thank you.
Thank you, Bernice, for that wonderful introduction. Thank you to everyone here, and first and foremost, the panelists for sparing the time and joining us for this, what promises to be a very interesting discussion. why is the Hague Convention and why is this discussion relevant today? The Hague Convention was adopted in 2019. It's been signed by 5 states until March of this year, and earlier this month, it was signed by the United States, which has now raised a fresh debate within the arbitration community about whether this convention will meet the fate of its predecessors or whether it will go on the path of the New York Convention and will turn out to receive the consensus that the New York Convention eventually received. And one more thing that's more relevant to point out right at the outset, it's something that Professor Stewart mentioned to me when we were having a discussion earlier, which is that this discussion is, the nomenclature of the convention may suggest that it's for recognition and enforcement of judgments. But even as a transactional lawyer, you will think about these issues, much like you would think about the seat of an arbitration while drafting a contract, that underlying commercial contract, before really moving on to the dispute. And so the implications of this convention are similar. And without further ado, I would now jump right into the questions. Professor Stewart, what is the history of the Hague Convention and why is this so important?
Thank you, Zaid, and thanks to the Georgetown International Arbitration Society for organizing this event, asking me to participate. It's really a great privilege to be on the panel with 2 practitioners who actually know a lot about what they're going to talk about. So it's a delight. The answer to your question, Zaid, what's the background, what's the need for this convention, can be put simply in one word: globalization. As people increasingly cross national boundaries and their international commercial transactions become more and more common, so too have disputes arising from those transactions. And when those disputes are litigated in the domestic courts of a country where the losing party doesn't have any assets, the problem arises: can you take that judgment and try to enforce it in other jurisdictions where there are assets? Fact of the matter, as I'm sure you all know, is that different countries, different legal systems have different rules and requirements on the enforcement of foreign judgments. As a result, a successful plaintiff can face real hurdles in obtaining satisfaction of its judgment when he tries to take it across to another country. There's even the possibility that the judgment won't have any effect and you'd have to relitigate the dispute all over again. So the 2019 Hague Judgments Convention, more specifically the Convention on the Recognition and Enforcement of Foreign Judgments, is aimed to assess and reduce that risk of non-enforcement. That is, to promote the circulation of judgments, to use the term that the Hague Conference adopts, by specifying, and here Article 4 of the Convention is the key provision. It says that courts in other states' parties have to give effect to final enforceable judgments from courts in other states' parties in civil and commercial cases without a substantive review of the merits of the decision. Now, there's a long list of conditions for recognition and enforcement, a list of permissible grounds for refusal. Article 10 allows states not to enforce certain kinds of awards, such as punitive damages, but by and large, this is a treaty that is intended to promote recognition and enforcement of civil and commercial judgments, somewhat the same way that the New York Convention says you have to recognize and enforce arbitral awards. So it's an alternative or a supplement to the New York Convention. Some practitioners, as we've heard, strongly prefer international arbitration for the settlement of their cross-border disputes. Others are less enthusiastic, given the challenges, and one might even say increasing challenges to the arbitral process. So costs, time, even problems of enforceability. But actually, I would suggest it's not an either-or situation. I think many practitioners, and I would ask my colleagues to respond, actually appreciate having the choice. It's not that one is better than the other in the abstract. It depends on the particular circumstance. So in a given situation, a party might say, Either arbitration or litigation is the better alternative. I don't know that one is always better or generally better. One have to look at it from the point of view of whether it's fairer, cheaper, more efficient, faster. But it's a good thing, I would propose, to have that alternative. And the Judgments Convention, if widely adhered to and fairly implemented, does offer that option to practitioners in an increasingly globalized world.
Thank you, Professor. That's an interesting if, because that brings me to my next question. That's to Alex. We had this before. We had the 1971 Foreign Judgments Convention, which, for lack of better words, was an abject failure. Do you think this convention will meet the same fate?
Thank you very much, Said, and thank you for the invitation to speak. First of all, before I try to answer your question, I'd like to answer the question about choice. I think it is good to have choice, and certainly in my experience with clients, it's really not a practitioner's choice. We just advise our clients. But there are jurisdictions around the world where the courts are very effective, and particularly effective in certain areas. And so you can find yourself, even as an arbitration practitioner, saying, I've got nothing, I can't tell you as a client that you should always go for arbitration, it's always best, it's always cheapest. Sometimes it isn't. And the courts in some countries, my own, for example, the UK, have, or England and Wales, I should say more accurately, have changed some of the aspects of litigation precisely so as to deal with the competition that arbitration was presenting. So it's good that we have this attempt to try to make a system for jurisdiction and enforcement of judgments akin to the successful New York Convention. So what went wrong in answering the question about the original, the 1971 Convention? Why did that go wrong, and what chances has this convention got of overcoming that? I couldn't tell you every reason why it went wrong, but I think, generally speaking, one of the reasons, and the most commonly cited reason, is the fact that the 1971 Convention required that countries not only sign and ratify the convention, but also that there would be there'd have to be bilateral treaties negotiated with each country in which it was, each convention country in which it was contemplated to have mutual recognition and enforcement. That was a complication that was too much, I think, for many countries to undertake. And so even if they signed the convention, few got round to actually moving forwards with that process, or few wanted to even contemplate going forward with that process. The other reason was that there was competition from the Brussels Convention. A lot of the countries that were first contemplating or were looking at this, looking at the convention, the 1971 convention, were European countries who had signed, who were parties to the Brussels Convention of 1968. They were moving slowly forwards with that. That convention has been very successful subsequently. The Brussels the Brussels Convention, followed by the Brussels Convention, the Brussels Regulations of 2001, and then readapted in 2012, I think it was. Among European Union countries, that's been very successful, and I think that many of them felt less of a need to conclude a broader, wider convention, especially when, and this is the third reason I think that it failed, there were concerns about the inequality between different justice systems. Some countries had more transparent, more effective judicial systems. Some were, sadly, and that remains the case to this day, blighted by corruption, inequality, lack of transparency, etc. And the idea of a very broad convention was, I think, without the ability to look very closely at any judgment that was presented for execution in a country, enforcement in a given country, was, countries were reluctant to face up to that. Now, today is the situation different today. The same concerns remain with regard to the differences between the quality of justice, transparency, lack of corruption, or presence of corruption, etc., in many countries. does the Hague Convention on foreign judgments, does that really deal with this, or will that concern remain? I think there will be concerns about that. I think there is, however, a difference between 1971 and today, which is that countries are, for example, European countries are now looking more globally than just simply dealing with their own relations. You have the fact that the Brexit, the UK has left the European Union, as we all know. He rolls his eyes. That means that the UK, for example, which is a very significant jurisdiction, what do you call it, shopping jurisdiction, a place where many people will go as a jurisdiction of choice to resolve disputes because of the effectiveness of the high courts and relative cost effectiveness as well. This has meant that the UK has signed up to these agreements, and that may be a factor which will, among other things, create more pressure to move forwards with this. But I'm afraid I think it's too early to tell whether that alone or in conjunction with the US having recently signed, will it ratify? Big question. I don't propose to answer that. I'll leave that to my US colleagues here. It remains to be seen whether that will actually happen. So I'm going to take when I don't know if anyone knows, Chu Enlai was once asked what was the influence of the French Revolution, and he said, well, it's too early to tell. And if that was his answer about the French Revolution, I think it is too early to tell whether this will be successful. The aims are laudable, but there are many barriers in front of it.
Thank you, Alex. Professor Profaizer, do you want to chime in on any of the things that you've heard so far?
Sure. So thank you very much for having me today. It's great to see you all here. Thanks for showing up on a Friday afternoon, a beautiful Friday afternoon, and it's great to see a number of familiar faces. I think Alex and Professor Stewart hit the nail on the head in that we're talking about globalisation, right? We're talking about competition, and we're talking about choice. And so we're thinking about all of those things as practitioners to give our clients the maximum impact for spending all the money and the time and the resources that they are going to spend resolving that dispute. And what this does, what this convention does, and I'm very happy to see that the United States as an outlier, as we talk about in my classes as well in many ways, right, with juries and punitive damages and things we'll talk a little bit more about in broad discovery. But it's very nice to see that the parties are given the choice, more choices, so they can choose not just arbitration, but when the case arises, when it's necessary, when it's helpful for them, when one side wants to choose the quality courts of a particular state, that they can do so, and they can have that confidence that the award, the judgment, just like an award that we'll talk about more, is likely to be enforced. And as we talk about in my classes, I often say this is a money point. The money point for you all as students, when you get back to your home jurisdictions or continue to practice here, is the question you need to ask at the beginning of the action, right? When the dispute begins is how are we going to collect? How are we going to, as we talk about, show me the money? And how are we going to ensure that all of this work, years of work that we will have engaged in, will allow us to take the money in the respective jurisdictions? So I think the Hague Judgments Convention is really important in that it's another step in that regard. I don't know, we'll talk about it, whether or not it's going to do the same things for litigation in terms of enforceability as the New York Convention did for arbitration, but it's a really important step because we begin with the end and begin with the enforcement, which is what clients care about.
Absolutely, absolutely.
Just to add one minor technical point for those of you who really get invested in this issue, you mentioned the 1971 Hague Judgments Convention, which went nowhere. One reason it went nowhere is that it addressed two issues, not just enforcement of the judgments, but also the question of what jurisdiction states parties could exercise. It was so-called a double convention. And those of you who can recall your earlier studies on, let's say, U.S. Supreme Court jurisprudence on the constitutional limits of jurisdiction will readily understand that our law is quite different than other states. And even, well, you mentioned within Europe, let's say within the European Union, there's a standardization. But around the world, there are many different approaches to jurisdiction. Simply was much too difficult to get agreement. The current convention, the 2019 convention, is a single convention addressing only judgments, which in theory should be much easier for states to adopt. But that's a point worth keeping in mind.
Definitely. Thank you, Professor. What's the role of this convention in supplementing the Hague Choice of Court Agreements Convention then? Does it take us anywhere with this present convention?
I'll take a shot at that, if you'll permit me. And actually, I'd turn it around. I'm not so sure that it's a supplement as opposed to maybe a different approach. That's to say, going back to this initial effort in 1971 convention on the double convention, when that didn't succeed, when folks in the international community realized doing jurisdiction was too steep a hill to climb, the efforts turned to a much more limited approach, which proved more successful. And that was that resulted in the 2005 choice of court convention. And that convention simply provides when parties have a contractual agreement to litigate their disputes in a given national court, then parties to the convention have to recognize that choice and allow those parties, if it's their courts they've chosen, to let them come in, not take the case if they aren't the chosen jurisdiction, and importantly recognize and give effect to the judgment. And that commitment to enforce contractual choice of forum clauses, if they're exclusive, proved much more successful. That convention now has been not very widely ratified, but it is in force and has, I think, 32 states parties, including folks in the EU. And so my point is, I think it is a precursor. It was a way of getting back into the game. It opened up the discussion. It's a more limited approach, but it's rather than supplementing, it's kind of the other way around. It opened the door back up for the Hague Conference to come back to this question of judgments in a more thorough way. It's been criticized by a number of people, particularly those who favor arbitration, but I think it's going to prove reasonably successful, and again, it's set the stage for the Judgments Convention.
Thank you. Would Alex or Professor Profaizer want to chime in on that?
Yes, I was just going to, you mentioned some of the criticisms of the Choice of Law Convention. I think the main one goes back to the profound underlying concern that one country may have in relation to the judgments issued in many other countries of varying degrees of reliability in their subjective view. And that's the question there's a difference between the Choice of Law Convention and the new Judgments Convention, and that is the ability to exclude judgments from given countries. I think it's Article 19 of the Judgments Convention that allows you to exclude, allows a state to say, I am not going to recognize the judge, even though the fictional country of corruptlandia, let's say, has ratified the convention. I am not going to. My state is not going to recognize judgments from that particular state. That isn't present, as I understand it, in the Convention on Choice of Courts, and that has been identified by some as a problem with it, because it creates, that's one of the key differences, as I understand it, between the two conventions, and it remains to be seen whether that adjustment in the Judgments Convention will make it more attractive for states.
So 2 points, just to pick up on what Alex said, because this is a really important international treaty point. It's, I believe it's Article 18 and then Article 29. They have a very unique provision in the new Judgments Convention, not in the Choice of Court Convention, okay? Not from that. So when we're thinking about the instruments, we have the 71, we have the 2005, and then we have the 2019. So there are three different legal instruments and we've been talking about sort of all three of them. But with respect to the 2019 convention, they have a very unique provision, although Professor Stewart can talk more about how unique it is. But it says it allows, for example, the United States to say, hey, I'm not going to recognize, we'll call it Islandia, right? The judgments of Islandia. So it allows what they call bilateralisation, which literally allows one country to say, I'm not going to recognize the judgments of another country. Now, the United States, and this is a big picture point that I want to make, this is really important. Why, when the United States was not a signatory to either of the two conventions, why did it so quickly sign this one? So think about it, right? A lot of foreign judgments are enforced in the United States because we have a fairly liberal standard for enforcing them under state law. That's a critical concept. But what the United States, is my suspicion, is and David can talk about his sources, and Professor Stewart can talk about his sources at the State Department, but we want to promote enforcement of U.S. judgments abroad, okay? So that's a key concept, I think, as to why the United States was willing to sign on to the 2019 Hague Judgments Convention. But that still allows other countries, and we'll see what happens, to say, hey, I'm not going to automatically enforce U.S. decisions, U.S. judgments, that is. So this bilateralisation provision exists, and I think that serves as sort of a relief valve in order to encourage other countries as well to choose certain, frankly, target certain countries where they feel like, hey, we're not ready to do that automatically.
Do you want to respond to that?
Sure. This is a tough issue, and it's always on the minds of both negotiators and frankly in the minds of the senators who are going to have to approve this. You mean you're going to obligate the U.S. to enforce judgments from the country of X, where a bunch of strange people are doing strange things legally and they don't have a real legal system and so on. If that were the case, then there's really no point in having a multilateral convention because it would pretty soon disintegrate it into a web of bilateralization issues. The other problem, if you were negotiating this, you'd really have to give some thought is country X may be a perfectly fine and well-functioning country today, but tomorrow they may be a revolution and they may go in a very different direction, and their courts still will be rendering, if we don't have the authority to shut that off, we're going to be exposed. The last point to consider is it's not just the reception of foreign judgments in the United States, it's the outbound U.S. judgments abroad. We all know that many countries do not like certain judgments from the United States, in particular those that contain punitive damages or treble damages. So this is a very tricky issue. There is a little bit of flexibility, as Joe has said, in the bilateralization point and so on. One hopes this will not be a major element in implementation. If the system begins to fragment and break down into, if you don't do it my way, I won't do it your way, etc., then the whole point of judicial commitment to recognize decisions and judgments is going to break down. Something to be watched. Going to be very difficult.
So not to take the prerogative of the moderator, but David, would you have included, if you were a negotiator at the State Department, or Alex, but particularly David, would you have included that bilateralization provision allowing the ability to opt out? Do you think that makes the overall convention more likely to succeed, or do you think it's less likely to succeed in light of that?
Yeah, I'm going to. That's a very good question, and I'm going to give you a very unsatisfactory answer. When the State Department negotiates something like that, they pay close attention to the desires of people in the commercial and legal communities, because we're not just waving a wand and saying you all guys are going to do it this way. If the litigating bar has real concerns, they have to be taken into account. And the same thing is true with the folks in the big building down the street here, who have an important say. So if I were there, I'd certainly have given it careful consideration. Whether I'd come out in a different way is irrelevant. This is how they came out.
Thank you. I don't think I'm needed here, but I would still continue. Alex, I'll just build on what's been discussed, and this is something I remembered when you were sort of framing this question. I was a student in Professor Profaizer's class, and one of the things that he would tell us is that the New York Convention, as it's named, as it stands, is actually sort of incomplete, because it should not just be the Convention on the Enforcement and Recognition of Awards, but also arbitral agreements. And that sort of brings me to my next question, which is, does the Hague Convention by itself, on a standalone basis, can it be the litigation equivalent of the New York Convention, or is it the Convention and the Hague Convention of 2019, the Judgments Convention, along with the 2005 Choice of Court Convention, that can potentially, compete with the New York Convention, so to say?
Yeah, I think it would. You're absolutely right about the way that the New York Convention bookends both these fundamental issues, a recognition of the applicability of arbitration agreements and their enforcement. And it does it in a very laconic and effective, many would say effective way. There are criticisms of it, but we can perhaps come on to those in a second. I think I would say yes. I think you need both the Choice of Court Convention and the Judgments Convention, simply because they apply to different areas, as I understand it. There's one applies to exclusive jurisdiction agreements, Choice of Court agreements. The other applies to a wider range of agreements, and has many more exceptions in it for that reason, because the degree of party autonomy is different when it comes to an exclusive Choice of Court agreement between business-to-business actors who have consciously chosen a particular court. It's very different where you have a wider exposure to the jurisdiction of a foreign court. And for that reason, I think you have to take them both together. I think it's very hard to say how far states will go in moving forwards with this, whether it will take off. A lot of it, there's a degree of kind of, well, you go first type of thing in all of this process, rather than just assessing the merits of the conventions. One of the problems that people face is that when comparing it with the New York Convention, is you have 60 years of jurisprudence, international jurisprudence with the New York Convention, not entirely always consistent. Some countries apply different interpretations of various articles of the New York Convention, but you can navigate by that jurisprudence. We don't yet have jurisprudence about how the two conventions that we're talking about, the Judgments Convention and the Choice of Court Convention, will be applied, how the various, in many ways more complex articles will be applied. To some degree, there's more clarity if you actually spell things out. What someone once said about the New York Convention was that what's not written in it, you could write a book about many books about what's not written in the New York Convention. There is a bit more flesh on the bones of the Foreign Judgments Convention, but how this will play out, how the various nuances in certain clauses, particularly where carve-outs are described and states are allowed to make no broader than necessary exclusions in certain cases, they're always difficult, and the jurisprudence that develops around that will be interesting to see. And how it will play out, I don't know. It may well play out very differently in different courts around the world.
That is interesting. Would either of the other panelists like to weigh in on this? Or I can move on to my next question then. So this is where we start getting into the technicalities of the convention, of the New York Convention and the Hague Foreign Judgments Convention. The attendees for today would have yesterday received an email with the texts of these conventions, so please feel free to open your tabs, your mobiles, your laptops to refer to the articles as and when our speakers refer to them, in case that's helpful. Professor Profaizer, my question is to you. How similar or how different are the obligations of the parties to the underlying agreement under the New York Convention and the Hague Foreign Judgments Convention?
So let me answer that for the group without anybody having to open up their computers. Hopefully, though, you all will listen to me then rather than check out the dinner menu. So let me make 2 points at a very high level. Again, takeaway points for the New York Convention as well as the Hague Convention, okay? Both conventions are, to state the obvious, my dad likes to say you're a master of the obvious, Joe. To state the obvious, they create international treaty obligations, okay, based on globalization. They create international treaty obligations among the parties and between each other and among an enforcing court both on the front end and then on the back end. So that's kind of the takeaway, if you will, as students, since I understand from Anne-Marie that we have only students here. These treaties create relationships among the parties. Both of them create relationships among the parties and among the enforcing courts. Okay? So they create a relationship that didn't exist by treaty before. And then the second way to think about it is both treaties both deal with the front end, okay? The front end of enforcement of the decision in the enforcing court, if you will, or the application of the decision in the enforcing court. Sorry, in the litigating court, the original jurisdiction, and then bookend that both for New York Convention as well as the Hague Judgments Convention and at the enforcement stage, okay? So they give effect to that concept for those of you who have been in arbitration classes or not. They give effect, both of them give effect to party consent, both at the front end with how the courts will be required to treat judgments when you're litigating in those courts, but also on the back end when you're enforcing those judgments or those awards as well. So I'd say that's a high-level perspective among the relationships between the parties and among the courts, and then both temporally at the front end when the litigation is commenced or the arbitration is commenced, and the enforcement of an agreement or an award on the back end.
Thank you. That's helpful. Alex, I was wondering, and I know I keep coming back to the New York Convention, but that really is sort of the yardstick that one would look at when you're sort of assessing a new convention like the Hague Foreign Judgments Convention. And I was wondering if what your thoughts are about why the New York Convention became this widely ratified treaty, and what path the Hague Convention would need to take to get there.
Well, I think picking up on a point Professor Profaizer just made, the Hague Convention requires courts to look at the beginning at both ends of the process. One of the and to get involved in deciding how to apply the convention. One of the advantages of the New York Convention is precisely that it keeps the courts at bay. It keeps them at arm's length. There is some involvement of the courts at each stage in the process, but not so much. And that, I think, has been the strength of the New York Convention, because it has over the years allowed courts to lessen their workloads in respect of disputes where parties have agreed to resolve disputes through arbitration. There is some supervision at the beginning. If arbitration clause is null and void, you can go to a court and say, I'm not going to arbitration. I don't have to, it's null and void. A court will do that. But by and large, the doctrine of competence has ensured that a lot of these questions are now resolved by arbitral tribunals. But, and here's the balance in the New York Convention and its great strength, at some stage, that decision by an arbitral tribunal will be reviewed again when you come to enforce the arbitral award potentially in another country, or where if it's reviewed in the courts of the state, of the seat of the arbitration. That is a great strength of the New York Convention. It keeps the courts at arm's length, but does not totally dispense with national jurisdiction or court supervision. It's, as I mentioned before, a laconic document. Sometimes that leads to problems with it. Sometimes there are issues that can be problematic precisely because, for example, they use the word may in a couple of articles, in Article 5, and that has created discussion, often, and controversy. And there have been arguments that, for example, in the beginning of I think in 2008, Albert Jan van den Berg, a leading arbitrator in the international arbitration sphere, proposed changes to the New York Convention. But by and large, it has survived, I think, because of its simplicity and laconic nature. and because it has kept courts at bay. Obviously, the Hague Convention cannot kind of lighten the load of courts in the same way, because you're going to have to go to a court to apply the convention. Whether courts will find it easy to apply this or not remains to be seen. I think both the New York Convention and the Hague Convention, as it comes to be applied, if it is ratified by enough states, will inevitably create differences between countries as they apply and interpret the convention. That always happens in these cases. Only time can tell how exactly it will play out. But the competition with the New York Convention is going to be tough. And really, at the end of the day, what I think will decide it is two things. It will depend on the parties as to whether they continue to be attracted by arbitration or whether they're drawn back to courts. If more parties go to national courts, there will be more pressure on national governments to consider how to make a more efficient system of enforcement, and this is the only game in town at the moment. There is no other on the table that has a chance at the moment of being made effective. So I think a lot will depend upon the way that commercial parties decide to move.
Just in the interest of generating debate, and we won't go on too long, we'll turn it over to questions for a little while, but one thing I want to follow up on what Alex said is at the end of the day, the courts, okay, in any national courts in any country, are going to have to be used one way or the other to enforce either an arbitral award or to enforce a judgment, okay? So we're all ultimately dependent upon the coercive power of the state, wherever that party's assets are, to enforce either an arbitral award or to enforce a judgment. So while arbitration gives parties some relief, if you will, some abstention, or requires, one of the most important goals of the New York Convention is to require a court to say, no, I'm going to abstain from making that decision. At the end of the day, in order to give effect to the New York Convention as well as to the Hague Convention, you still are going to have to, as a practical matter, go back to the courts to get it enforced. So we just have to kind of keep that in mind as practitioners, as professors, and as people who are thinking about the rule of law, both for our clients as well as more broadly.
Professor Stewart, do you want to say something to that? Because my understanding is that this whole notion of the New York Convention being a self-executing treaty is the subject of criticism in Professor Stewart's upcoming article. So I'm wondering if you have any thoughts.
You want to give us a preview already, Professor?
Well, I would take issue with the proposition. I know it's been advanced by prominent people that the New York Convention is self-executing. It's been executed by legislation, therefore, by definition, it's not self-executing. But this raises a really important point that I think offer in supplement to what my colleagues have said. If I had to make a rule, I would say treaties are more likely to be successful the simpler they are. And the Judgments Convention is way off on the not-so-simple line. It's a pretty complicated treaty. It's got a lot of articles, a lot of exceptions, a lot of conditions, and that's a result of the fact that different countries have different approaches and different interests, and they had to protect them. By comparison, the New York Convention is a very simple thing, and its implementing legislation is very simple. If you look at the more recent convention, the Singapore Convention on Mediation, which is a very simple, it's taken off like a banshee. It's got a lot of parties now. People like that. So there's another element here. So I think in general, even if, let's say the United States were to ratify the Judgments Convention, it would have to be implemented legislatively, and it would pose a lot of burdens on courts. There'd be a lot of litigation. And I think that's a mark against it. It's a delight for lawyers, particularly those who want to frustrate enforcement of judgments. A lot of things to do. But on the whole, simpler is better. We'll see if my prediction is right, but that's just my instinct.
Thank you. That's interesting. Professor Profaizer, I'll stick with you and I'll ask you the last question before we then sort of come back to all of you for your final takeaway. What are the differences in the grounds for the recognition for refusal of recognition and enforcement in the Hague Convention and in the New York Convention.
Thank you. So let me keep it high level, just again, as a takeaway for helping people to kind of remember the concept. So the first is in the New York Convention, right? Again, party consent is critical, and Article 5 provides then for certain exceptions to enforcement, okay? And with respect to the Hague Judgments Convention, the exceptions are found actually throughout, to build on what Professor Stewart was saying. What do I mean by that? I'll get to that in a minute, but let me give a higher level. So the public policy exception is a similarity. The due process exception and notice is a similarity. Both conventions or both treaties prohibit or allow a court to refuse enforcement of a judgment or award if there's a violation of public policy or if there's some fraud or some due process issue. The concept of arbitrability and whether or not something is arbitral, that's not obviously in the Hague Judgments Convention because the concept of arbitrability doesn't exist for the New York, for the Hague Judge, for a national court. But I want to make a second point, which is building on what Professor Stewart was saying. If you look at it, and I know we sent you the link, but if you look at the Hague Judgments Convention, you're going to see a lot of qualifications on different things. In other words, there's filters, what the drafters call filters, in which certain jurisdictional requirements must first be met. There are also in Article 2, for example, intellectual property is not part of the Hague Judgments Convention. And then there is, it's Article, I think it is 7, bear with me, Article 7 of the, Article 10 damages, which is what my colleagues were talking about before, in which enforcing court for the Hague Judgments Convention can refuse to enforce if the damages don't match the actual damages. So in other words, that's a target for U.S. punitive damages. So there are a number of similarities, but there are also a number of differences. And the Hague Judgments Convention is far more complex, and there are a lot more qualifications of things that will not be enforced, as the case may be, because the national court systems are so different.
Thank you. That's interesting. I will now ask the core question of the panel. Can the Hague Judgments Convention change the game? And what can we expect from the future? I would probably stick with you, Professor Profaizer, and go this way and end with Professor Stewart.
Sure. So I think that globalisation, competition, and choice are the name of the game in this period, even though it's a troubling period in some ways, and we'll see how that affects the order legally. The rule of law is still going to be very important. There's still going to be an awful lot of international commercial transactions that are going to continue to grow. And so I think, asking, does it have the option to change the game is sort of like, as we talk about in my class, what do you think's better, chicken or beef, right? I think they're different. They can be complementary, and both can exist on the plate if you're hungry enough. So that's where I'd leave it.
Thank you. Alex?
Thank you. I think it does have the possibility to change the game. If enough countries take up the ball and run with it, that remains to be seen. But if they do, all of the complications that we've mentioned, and I agree, it is very complicated, well, they will play out and they'll give lawyers a lot to argue about and talk about, but it could very well change the game. Often people say, is this the new New York Convention? I think really it's more like, will it be as successful as the Brussels Convention, the way that the European Union has managed to take disparate legal systems and create an enforcement and recognition regime that works pretty well. Can you do that over a wider area remains to be seen. If it does work, that really would be a game changer. The question is what's going to happen with different regimes and whether inequalities between the quality and transparency of certain legal systems. Will they be cut out and put in the wilderness, as it were, by exclusions and bilateral invocations of Articles 18, 19, 29, etc.? I don't know, but that's going to be the most interesting question, because I do think it will be difficult to create one kind of European Union of the entire world. Certainly in my lifetime. I'd like to think so, but I think it will be difficult. But yes, it could be a game changer.
Yeah, the prospect of a global European Union is really a very interesting one. Maybe it's easier to standardize, unify enforcement of judgments within a group of countries that more or less share a common tradition. The UK, different, of course. But globally, that's a much bigger problem, I think. I wouldn't want to bet on the success of the 2019 Judgments Convention yet, but I wouldn't bet against it either. I think it's going to be incremental. If I can just take a moment, I thought it would be important to just introduce you to a related problem that will arise with regard to the consideration by the United States, which is a problem that many other countries don't have. And that has to do with the simple fact that in our system, as many of you know, enforcement of judgments remains almost entirely a question of state law. There is one federal statute, which in my view was unnecessary, that deals with judgments that are contrary to the Constitution, or particularly the First Amendment. But apart from that, enforcement of judgments in the United States is a matter of state law. There's a high degree of uniformity because there are two uniform laws, but the fact is that neither of the uniform laws is adopted entirely within all the states, and there are some states that haven't adopted either of the uniform laws. It's very different from the question of enforcing sister state judgments within the Union, because that's covered by the Constitution. Why is this relevant? Well, under the Constitution, as you remember, treaties become federal law. Can't get around it. Therefore, if we were to ratify the treaty, we would federalize, one way or another, inescapably, we would federalize the enforcement of foreign judgments. Think for a moment, who wouldn't like that? There are 50 of them, we call them states. They'd say, why you gotta take away our judgments enforcement just because you got a treaty? And the answer is, well, the founding fathers and 1789 and so on. The practical problem is when you go down to the big building down the street here, treaties have to go to the Senate. And the Senate consists of senators, and it requires a 2/3 majority, that's 66 of them, have to say yes. The practical fact is that the actual number is no 2 or 3 senators vehemently opposed. If there are a significant opposition, the treaty just doesn't go anywhere. And so you can see the problem immediately, where some folks, practitioners, business interests, would say, we don't want a treaty that takes this issue away from our courts. This problem is not hypothetical. It's been what's held up our discussion of our consideration of the Choice of Court Convention in a somewhat less difficult situation. So I anticipate even if the government, having just signed the convention, does move forward, there'll be a big discussion about how to implement this treaty. And it'll be really tricky. I think the only way to do it is a cooperative, what I call a cooperative federalism joint mechanism, because the federal government has to ensure that if we ratify the treaty, we comply with the terms. And you can't have a situation where a judge in a state court in one state says, well, you got your treaty, but I'm not going to do it. That's not possible. So we face a problem beyond the details of the convention in the way it will affect the U.S. legal system. So keep your eye on that one. In the end, it's going to be not the government that makes the decision. It's going to be the practitioners and the business interests. The government listens to that. And I think if there is substantial support from the private lawyers and their clients that this is a good thing and good for them, then there'll be real pressure to see if some sort of an accommodation can be worked out. If the people for whom this treaty would be a potential benefit say we're not interested, then I don't think it's going to go anywhere. That's simple political fact.
Thank you. Thank you for that. We now invite questions from the audience. If anyone has any questions for our panelists. Felipe? Yeah, please go ahead.
I wanted to ask you, looking beyond the text of both treaties, the York Convention and the Hague Convention, I'm thinking that the York Convention really worked throughout the years because the judges in the national courts would recognize the awards based on the authority
Well, I get all the good questions. Absolutely. I think it's fair to say, my colleagues on the panel can educate me, but I think it's fair to say that judges have generally overcome their reluctance to recognize and enforce arbitral awards and to enforce arbitral agreements. I think if you look at it historically, there was greater suspicion and reluctance initially back in the history of it, and today they're pretty comfortable with it. Enforcing judgments from a foreign country going to be more challenging. I give you one very recent example that comes out of the New York courts. I'm sure you guys have seen this, but a trial court in New York recently refused to enforce a judgment from the People's Republic of China on the grounds that it was simply impossible to get a fair trial in the courts of the People's Republic, systemically invalid. This was based in part on the judge's reading of the human rights reports that are published by the State Department each year, which are not intended for that purpose. And not fortunately, the appellate division in New York has reversed that decision, I think, quite properly. I'll reveal that I was on a brief saying that. We succeeded. But that's an illustration of I think, and it's not unique to the United States, but you have a judge who says, look, I don't know that system. I don't know what it's like. I've got one party telling me it's just awful. Look what they've done. I'm reluctant to, I don't have any ability to really get into the details, but what that party has said doesn't sound right to me. It's not what we would do here, so I'm not going to give effect to it. That's an instinctive reaction. That would, I think, make it more difficult to implement. And so we could call that the control function. It exists in arbitration too, but probably more likely to occur in judgments. Ongoing issue. Does that make sense to you?
Yeah, I would agree with that. I think that with arbitration, you can, when a judge is looking at an arbitration award, and whether to apply the various narrowly defined grounds for not enforcing an arbitral award. Some of those are to do with the way in which the arbitration panel was appointed and so on. But the advantage of arbitration is that it's precisely that the parties get to choose the panel. So even if the arbitration is seated in a country which has, let's say, questionable courts that are not particularly efficient, you can still look at the arbitration tribunal and go, well, they look to be competent people. The manner in which they're appointed, the degree of consent from the parties, etc., gets around to a large degree any problems, any issues I, as a judge, being asked to enforce this award, might have about the courts of that particular country. So that's an advantage of arbitration over the kind of when you, as opposed to having to look at the integrity of an entire court system and the extent to which you can or cannot take that into account as a judge being asked to enforce a judgment from a foreign court through the convention. Though the grounds are more widely and more specifically enumerated in the convention, still things are going to fall through the cracks, and these wider concerns that you may have, there isn't room for all of those. You can't just say, well, I'm suspicious about the Chinese courts in general. Correctly, I think you can't do that. You have to identify something very specific, and often you can't specifically identify that particular court in that particular country is not reliable, and that can be a problem. If you've not got any evidence, then there is a convention that compels you to enforce, then you've got to enforce. And that, I think, is the root of the concern.
So, fantastic question. Let me come at it from a different way, which I think gets at maybe the gravamen of what you're asking. I think my colleagues addressed it very nicely, but you're asking a really interesting question about how is a judge sitting in the United States going to feel about another judge sitting in China, for example? Or how is a judge in Venezuela going to think about what another judge might be doing in, let's say, Germany, right? And how a judge might in Russia react to another judge in India, for example, and how those judges sort of think of themselves vis-a-vis each other versus how each one of those judges might think about an arbitrator who's a lesser being because they're not created by the coercion of the state, right? So I think maybe building off, I don't know, this is one of the points that Alex was getting at. I'm admittedly doing it from a more psychological perspective. But so those arbitrators then are, I think, picked because they are picked by the parties, and there's an element of consent there, whereas those judges are not picked by the parties. That allows one judge to sort of say, okay, who's deciding whether or not to enforce, how he feels about the parties vis-a-vis the arbitrator, as opposed to how he may be feeling about that other country's state agent. Okay? So I think a judge in China, for example, can make a much, if you more I'm going to just call it relaxed, I don't know that's the word, but a more relaxed or a less critical decision about an arbitrator sitting in New York than a judge in India may make about a judge, if you will, in Germany or whatever. So I don't know the answer to the question, but I think those are some of the dynamics that are going to be going on with the Hague Judgments Convention that don't necessarily or do go on with the New York Convention because of the very different nature of judges and how they see their gatekeeping function as opposed to arbitrators, how they see their function, I think, properly as executing the consent or the will of the parties.
Thank you. We'll take one last question. Paulina, yeah, please.
Thank you for the panel and for this lecture. My question is less interested in that this, but I wanted to ask, is there a reason why in the 2005 and 2019 convention, when the convention defines what is a judgment, it excludes the interim measures judgment? How would it be? Because it also encompasses in the judgment a decision regarding costs and expenses. So it's kind of interesting to see why a decision regarding costs and expenses fits into as a judgment and not an interim measure decision.
Well, one of you want to take.
I'm not sure Alex, do you?
Well, I think I don't know the reason. I haven't looked at the notes and to see if there is an explanation of that point. I can only imagine that if they exclude interim measures, it would be because that's something that's to do with the litigation while it's in progress. And the idea, as we discussed earlier, of the conventions is to ensure that you establish where litigation can start and is it in the right court and is it applying the right choice of court's agreement, and then is it enforceable when the judgment has finished. But in the interim period, I suppose the idea is that it's for the courts who have established themselves or been established in accordance with the convention to be the correct courts to run their own show, and trying to enforce interim measures abroad would be really for that court to decide. I don't know whether that would exclude, I'm just thinking out loud, there are ways in which a judge in a piece of litigation in a case can order certain things to happen. And there are existing conventions, for instance, the Convention on Taking Evidence of 1970, I think it is, the Hague Convention, and the Service of Papers Convention of, I think, 1968 or 65, I forget which year it is exactly. There are ways in which you can enforce already interim measures and requests for evidence, letters rogatory, etc. So I would imagine that the idea is to avoid doing that, but I haven't looked into all of the travaux préparatoires and all that kind of thing to see if that's precisely what they were thinking about, but I can imagine that might be why it was.
I think the idea was also comity and to ensure, because there's Article 4, Subclause 4 of the Convention that talks about a judgment would only be enforceable if it's not subject to review in the host state. So I think the idea is not to have an interim judgment and then that be turned around and then enforce something that's against what the final judgment in the main country and therefore not disturb the principles of comity and
Yes.
international relations. That would be my guess. So thank you. I think that concludes this panel. Thank you all. Thank you to the panelists. Can we please have a huge round of applause for them?
Thank you.
Oh. we can keep this conversation going with some drinks and food. So please help yourselves to some drinks and food upstairs. Thank you.